Good evening. This is Making the Case. I'm Yodit Tewolde. So far, much of the trial for the former Minnesota officer charged with killing Daunte Wright has focused on emotional testimony and graphic images. Today, the prosecution focused on raising questions about how an experienced officer can confuse a taser for a gun by showing the differences between the two for the jury. The jury listened to hours of testimony on the police department's use of force policies, taser training, how they function, and other details. My legal experts are here to discuss today's testimony. Veteran prosecutor and BNC's legal contributor Paul Henderson, also with us criminal defense attorney and vice president of the Atlanta NAACP chapter, Gerald Griggs. All right, welcome you both to the show. Let's get right into it. The judge denied two motions filed by the prosecutors. One asked to limit the opinion of witnesses who are not testifying as experts. This came after Sergeant Michael Johnson, the officer who was with Potter the day Daunte was shot and killed, testified last week that the defendant's actions were justified under state law. Johnson testified as a witness, but not as an expert witness on the use of force by police. The second motion was a request to question officers about union membership since Potter served as president. Prosecutors argued that gave her an elevated level of respect among her coworkers and wanted to ask officers about it to evaluate any potential bias toward the defendant. Paul, you talked about this yesterday. What are your thoughts now that the judge has weighed in?
I think that those were really important motions that the prosecution needed to make. I was quite frankly surprised, though, that when that testimony did come in, that there wasn't a bigger objection from prosecution when it happened. Even if it was a speaking objection where they articulated why they had concerns about that officer testifying, I had expected something more than these motions that they're bringing now, because the cat is already out of the bag. The testimony exists. The jurors all heard it. And I think it did hurt their case for that officer to say that he would have shot, that he thought that according to statute, that the shooting could have been justified under those standards, because it still raises, I think, new arguments for the prosecution to have to address. And they're fighting a legal battle now, interpreting legal interpretations from what this witness said on the stand. That's never the position that you want to be in from prosecution. You really want to keep the focus of your trial on the defendant and the defendant's actions. So it's one more layer that they've got to build in order to bring the jury to a verdict.
And Paul, this was a state's witness. You would think that they would know what he was going to testify to. So why bring this motion after the fact?
Well, I think to try and put the cat back in the bag. And I think that's also why you're seeing this second motion where they want to articulate and talk about the influence of the defendant because of her union status on even the prosecution's witnesses that are in law enforcement. It's part of the same argument, but that's exactly why I think they're bringing the motion, so that they can argue that she has influenced even their own witnesses to be supportive of her and to try and say something about her because of the position that she had. And keep in mind, we're still not hearing from some of the bigger names in the department like we saw in George Floyd. I would love to see the chief of police get up there and condemn the behavior, to talk about this is not policing. This is not what the training was. This is not what I expect from my officers. But the state of the evidence is what it is. And this is what prosecution has left to deal with. And that's why they're bringing these motions and making these arguments.
Gerald, did the defense gain any ground with those rulings from the judge?
I think the defense gained ground because, as Paul just stated, that testimony from a state's witnesses is very damaging to the prosecution. Anytime that you can inject reasonable doubt with one of their own witnesses, you are in a better position as a defense. And then for the judge to not allow them to fix the issue through their motions speaks to where they are in their case, and now they've injected doubt into the case. So I think it's a win for the defense. It's unfortunate, given that this is the type of case where I don't believe it was justified, but I do believe they scored points with those witnesses, with that witness, as well as with the denial of these motions.
And Gerald, what about the judge's rejection of the motion where the prosecution was requesting to question officers about union membership? She says that Potter is no longer connected to the police union in any way, and testifying witnesses couldn't possibly be biased to testify in her favor because of her position. Even though she isn't a president or hold any position in the union, she still has union lawyers defending her.
Absolutely. She has the backing of the union. And so, I mean, that's absolutely the proper place to question about potential bias or potential reasons to curry testimony. I disagree with the judge's ruling in this particular matter, but I do understand her legal argument. I think that this is a question of fact that should go to the jury. The jury should be able to weigh the bias or lack of bias of a potential witness. But I do understand where the judge was going because she's no longer in the union. But I think it goes to show a reason to have bias toward this witness. And I think that's always the purview of the jury.
All right, guys, let's talk about today's testimony. The first witness on the stand was Brooklyn Center officer Garrett Fleisland. In direct questioning, he testified that according to Brooklyn Center policy, a gross misdemeanor warrant, which is what was issued for Daunte, is not serious enough to initiate a pursuit. So, boom, 1 point for the prosecution. But here's what he said to the defense on cross-examination.
And if somebody's outside of a vehicle and there's a bench warrant for a weapons violation, and if he tries to flee, you can use force to stop him, correct? Reasonable force.
Yes.
And if he keeps resisting after using the physical force of pulling on him, getting him out of the car, you can also use other forces, like a taser, correct?
Yes.
If the car isn't moving. And if he still persists on it, after the man is warned that I'm going to use a taser, and he keeps fighting, and another officer is now in the car trying to stop him.
Objection.
I'm not done with my question.
The objection is overruled. You may finish.
And another officer is in the front seat laying over the passenger trying to stop this guy from going. And he is ignoring the warnings, taser, taser. I'm going to tase you. You have a right to use deadly force to save that cop, that police officer that's lying over the seat, correct?
Calls for a legal component.
The objection is overruled. You may answer.
Potentially, yes.
Now, defense counsel talked in hypotheticals, but we clearly know that he was trying to evoke the situation between the defendant and Daunte. So did yet another state's witness hurt the prosecution's case? Paul.
I don't think that he hurt the case, but it's going to be the prosecution's job to rehabilitate the testimony and to point out to the jury that these hypotheticals are so attenuated and that can't be cut like slices of a cake. You have to have the whole cake. It's not an individual, theoretical, hypothetical possibility of what happened. Here is actually what happened, and this is part of exactly why the prosecution is going to have to shift and focus on all of the training and the totality of the training that would have condemned and would have prevented this exact shooting. This hypothetical is a distraction to the jury if they're paying attention to it from those singular questions that don't necessarily correlate to everything that happened in the case. So yes, I guess it's another thing for prosecution to have to address. This is something that's typical in a case like this, and it's going to be the prosecution's job to explain it to the jury so that they understand the totality of the circumstances that condemns the defendant's behavior.
Gerald, your thoughts on that?
My thoughts on it, it's causing the prosecution to go on the defense. And anytime the prosecution's going on the defense, they are losing their case. When you have to correct your own witnesses and now in closing, the defense is able to use your witnesses against you, that's a problem for the prosecution. I think it's going to be an issue that they can overcome simply because he said it's possible. But they can spin back to the actual facts in this case and the actions of the defendant. The defendant never believed that she was going to use her weapon to use deadly force. She thought she was going to use the taser. And so I think that you can spin back, but even when you're having to do that, you're already on the defense.
All right, guys, Paul and Gerald will be standing by as we talk more about today's testimony from day 5 of this trial, including the hours spent focusing on Kim Potter's taser when making the case returns. The prosecution continues to make their case for manslaughter against the former Minnesota cop charged with killing Daunte Wright. Back with me to continue our discussion of Day 5's testimony is BNC's legal contributor Paul Henderson and criminal defense attorney Gerald Griggs. Potter's taser was the focal point today. Brooklyn Center officer Garrett Flesland testified that their policy is to carry their gun on the dominant side and a taser on the other side in order to avoid confusion. The prosecution showed several exhibits from Potter during other traffic stops dating back to 2016, showing that's where she kept her taser. That's also where her taser was the day she shot Daunte. Greg, why is that so significant to point out for the jury?
I think it's important to show to the jury to make sure they understand that the taser is kept on a non-dominant hand, so it's impossible for you to mistake a gun for a taser. And then to show that this officer, through other experiences and training, should have known better that her non-dominant hand would have reached for the taser and not the weapon. And so I think that they're trying to make sure the jury completely understands that there's no way she could have confused a taser from a weapon, and based on her training and experience, she should have known better.
Another officer, Mike Peterson, went into even more detail about the taser, but he also demonstrated how it's supposed to be tested, something a special agent assigned to investigate this case says Potter didn't do the day of the shooting. Let's watch.
I carry my taser on my left side. I'm going to draw it. As I draw it, I'm going to press both arc switches, one on the left side, one on the right side at the same time. It now eliminates my CAD. Tells me that I'm in a function test mode. I can then turn on my taser. My CAD has changed colors. I know that it's now in a function test mode, and now I simply press my arc switch again. It runs through a 5-second spark test.
Paul, we know how effective visuals are, but why was this even more effective to have this demonstrated before the jurors?
Well, the testimony about the training is extremely important. One, the jury is paying attention to it and they're leaning in to hear and understand what her training was. And two, it explains and challenges, I think it elevates the expected behavior from her specifically because she was a trainer, because she had done so much of the training. They went through all of her history. She had done the training 7 different times with a perfect score, and she still made this tragic mistake, which was just terrible in this case. So I think the important thing is pointing out all of the things that she was expected to do but were not done, and that's why they had this testimony and the visuals explaining to the jury what needed to happen.
Or there. Now, listen, Gerald, prosecutors asked to have the jurors handle the taser, but the judge didn't allow it after the defense attorneys had objected. But the judge did say that she would allow jurors to be able to carry this taser or hold the taser during deliberations. Why do you think she denied the prosecution's request for that?
I think this judge is trying to use extreme caution in this case and trying not to have to retry it. But I think that particular ruling was a mistake. I'm glad that she is going to allow them to handle the taser because that's an essential issue in this case. The difference of weight between a gun and a taser and the inability to confuse either one. So I think that particular ruling is questionable at best. But I'm hopeful that, she's allowed them to handle it at some other time. And I think that will be the crux of the case. So I really don't know why she felt the need to not allow them to handle the taser at this particular point, but they do need to touch that piece of evidence.
Well, the defense didn't get to cross-examine, or at least finish cross-examination of that officer who demonstrated the taser and talk about it being a newer model. Paul, when cross-examination resumes tomorrow, what kind of questions do you expect the defense to ask him?
Well, I would start over again with trying to republish it and let the jury see it if I were the defense. Because anything that the judge isn't letting them do, I renew again just to be a distraction for the jury of, if you could see it, you would understand my argument and understand my point. But separate from that, the defense is going to continue talking about the limitations or the similarities of that taser to an actual gun, because this is their main argument. Their main argument is that this was a reasonable mistake and a tragic mistake. And the secondary argument is the use of force that they are going to argue is justified. But part of that argument in defining that the taser is similar to the gun is the justifiability of the mistake of reaching for one and not the other, and even when you have it in your hand. And they're going to try and ignore and diminish all of the differences about weight, size, color, location, training, and instead focus on, oh, I see it's the same color as the gun. Oh, I see you're holding it in your shooting hand. Oh, all of those things are going to be brought out in front of the jury over and over again so they can hammer home how this mistake could have happened, and it's reasonable, even though that's counterintuitive to the testimony from the trainers that were on the stand today.
Gerald, there was testimony about a performing of a function on this taser that has to happen at the start of every shift, and that Potter didn't do that. On cross-examination of that particular witness, they acknowledged that this policy, even though it is something that officers are supposed to do, it might not be complied by officers widely throughout the department. Now, this is a 26-year veteran. I'm talking about the defendant, and she was training someone that day. Should it matter that other officers don't comply with this policy when she should have complied with it at the start of her shift?
I believe it's another red herring that the defense is trying to put up there. I mean, you have a 26-year veteran who's actually training an officer that day. So you would think they would go through all the policies and the procedures to make sure the new officer is trained appropriately. Making excuses for a veteran who's supposed to have the expertise and the experience and the training would not bode well for a successful defense. I think in this particular case, they should be best to say that she was mistaken and forgot that particular policy, and that, you know, not comparing her to other officers. Because when you start comparing her to other officers, you start to bring in the argument that your training was not superior, your experience was not superior, and you made a rookie mistake.
All right, Paul Henderson, our BNC legal contributor and veteran prosecutor, we're saying goodbye to you. Thank you so much for your brilliant insight.